Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for 3 cases to be submitted. The case of State versus Appellee is hereby submitted without oral argument. Our first oral argument of the afternoon, is Smith versus City of Cedar Rapids. It looks like the parties are ready. Mr. Limkemann. Did I say it right?
Yes, sir.
Or close enough? You're not going to correct me? All right.
May it please the court, counsel. My name is Skylar Limkemann. I represent Officer Antoine Smith and the Iowa Fraternal Order of Police, of which Officer Smith is a member. We're here today to argue that this court should reverse the district court's ruling on a motion for summary judgment regarding its interpretation of the Peace Officer Bill of Rights, Iowa Code Section 80F.1. I'll refer to that often as 80F.1 or the POBR. The primary issue in this case is the district court's interpretation of this statute is inconsistent with the text, purpose, structure, and legislative history of the Peace Officer Bill of Rights, particularly 2 subsections, 80F1 subsection 3 and then subsection 9. The operative text that we're primarily concerned with in this appeal is the investigation language of 80F1 subsection 3, where it indicates when the investigation is completed, and then in 80F1 subsection 9, where it indicates upon request at the completion of the investigation. Officer Smith is arguing that for the purposes of this appeal, the analysis as to when the investigation is complete is really the same under both subsections. Turning to the text, starting with...
Question about that, because I find this statute, it's sort of, an accumulation of different amendments and things over time, but subsection 9 says, if a formal and administrative investigation results in the removal, discharge, or suspension or other disciplinary action, copies of the witness statement, the complete report shall be timely provided upon the request of the officer. So that makes it sound like you don't get anything until there's removal, discharge, suspension, or other disciplinary action. Is that incorrect?
The 2021 amendments to this particular code section added language with regard to upon the request of legal counsel upon the completion of the investigation. That language was not present in the original drafting of this statute in 2007. And so the legislature, in adding that language, obviously meant to provide officers through their legal counsel the right to have the written report and the witness statements at the time of the investigation being complete. And the purpose of that section is to provide officers with the ability to have the witness statements and the complete investigation report prior to going into a Loudermill hearing.
You're saying that subsection 9 applies before the discipline hearing itself?
Correct.
Counsel, what do you make of the problem that effectively takes away the first 12 or so words of that phrase? Because it says here that the rights under 9 only apply if there's the investigation results in removal, discharge, or suspension. Until a decision's made, you can't say whether there's going to be a disciplinary action or not, right? So
the issue in that is that there's the upon completion of the investigation language. That was a new condition added to the statute. So you have the if of the original portion of it that results in, and then you have the upon completion of the investigation. It's not a perfectly worded statute. Obviously, this was done in 2021 when COVID was going on. This was part of the legislative back and forth between the House and the Senate, as the legislative history indicates. And what they did as part of this broader bill, this was put into an omnibus bill with a bunch of other provisions, and it was called the Back to Blue bill. And so when they did that, some of these other provisions were combined into one, and this was quickly added in through the legislative history, as that shows.
The only section that you're relying on for the right to get the investigation report, is that correct? So what happens in a case where there's no disciplinary action imposed?
still get through legal counsel, can still get the investigation report and the witness statements, and that's to give effect to the rest of the provisions in the statute, including the right to sue any person under ADF 1 subsection 13. Because we know that every investigation doesn't result in disciplinary action. And so to give effect to the statute, we have to read the upon completion of the investigation language. Otherwise, an officer theoretically would not be able to get the witness statements to determine that somebody was lying and made a false complaint against them. Or, for example,
On the issue of suing, is there also an administrative action ongoing, or was there one?
particular case, so there was a civil service appeal that was stayed pending the outcome of this district court case.
I'm wondering if the actions that you're complaining of aren't agency actions, and in fact that the exclusive way to court might have been through first administrative proceedings and then 17A.19 judicial review.
Does not apply to these proceedings, Your Honor, because 17A only concerns state agencies, and the text of the code does not actually make ADF 1 subsection 13 actions the exclusive remedy. This is a civil service city under Chapter 400. One of the reasons why the legislature, through the legislative process, designed the statute without the exclusive remedy requirement was because a civil service commission is made up of lay folks. They're not judges. These are statutory interpretations issues. A lot of times these are legal issues. They become very complex. They're not well suited for civil service commission. And some of the things that an officer can get as far as a remedy under this code section are not applicable under Chapter 400 appeals. For example, there's no reasonable attorney's fees, there's no right to an injunction, some of the damages are different, and so the legislature has allowed officers to pursue both ADF 1 subsection 13 actions and pursue an appeal. Also, not every officer has civil service available to them. So in Iowa, the vast majority of police officers do not have civil service rights because civil service is only reserved for the largest cities by the 1980 census under Chapter 400. And so you have some officers that are state officers that would have 17A potentially. You have others that have Chapter 400. You have sheriff's and deputies that would have 341A. And then you have everybody else. And then we also have to remember that officers just doesn't apply to police officers. We have firefighters, we have EMS providers, we have dispatchers, we have telecommunicators, parole, probation, and corrections officers. And so when we look at these systems, the legislature had to design a statute that pretty much works for everybody. And with all the different systems, this is what they came up through the legislative process.
Struggling with your reading of the statute is, it seems like the right to receive the investigative report is a conditional one. So 80F 1 sub 9 says, if a formal administrative investigation, blah, 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 blah. And I think what you've just told me is that the if is meaningless, because whether or not the officer is disciplined or not disciplined, there's still a statutory right to the investigative file, right?
Your Honor.
How do I reconcile that when it's pretty clear it's a conditional right?
Look at this code section in the context of not only the rest of the Peace Officer Bill of Rights, and we have to read it in context with those other provisions, in addition to the constitutional rights that public employees have, such as police officers.
So what are the other provisions that would make this a non-conditional right? What statutory provisions are you looking at?
The Loudermill, Your Honor. So for this to happen, the officer would have to have something to be able to respond to before they go into a pre-discipline hearing. And that's the very purpose of having the written witness statements and the complete agency's report is so they can go into the pre-discipline hearing and that these issues are addressed. And then that gives the officer the opportunity to respond. And let's say that there's a flaw in the investigation, as I put in my reply brief. The officer can bring forward other evidence and say, no, you got the investigation wrong, here's some additional evidence. Or, for example, there are situations where officers may have additional witnesses that, they do not know, the police department may not know existed at the time, and they say, hey, you should go talk to this person. And so that allows an opportunity for the investigation to be reached on the merits and to get the right result prior to any actual discipline being imposed. And that was the idea behind this with the legislature, was that We want to get to the bottom of these types of complaints and these investigations so that we're ultimately getting to the right result. And that's just basic due process under the 14th Amendment as well.
That makes absolute sense. But outside of ADF 1.9, what other code provision provides that process?
Isn't one, so you have to read them all together.
Sorry, you talk really fast. You said certainly constitutional rights. Was there another code provision that you identified, or you said something else that was outside of the police officer Bill of Rights? Was there something else that you mentioned?
So reading in ADF 1 subsection 3 where it terms the results, so we read that code section with ADF 1 subsection 9, and then we have to read that with ADF 1 subsection 1C, which is the definition of the formal administrative investigation. And all these operate in a scheme. And then when we look at the structure of the statute, this just makes logical sense because you start out under ADF 1 subsection 5 receiving a written summary of the complaint. So you get a little bit of information of what this is about. You complete your interview. And then after the interview, the department may do their investigation activities, and then you get the results of the investigation. And then from that point, it gives the officer the ability through legal counsel to get that complete witness statements and the report, because if there is going to be some kind of administrative charge, you have to be able to respond to that at a pre-discipline hearing. And so the fundamental idea of this is that as you structurally look at the code, you get a little bit of information at the beginning, and then you get more information through the end of the investigative process. And then we switch over to the discipline process, which would include the Loudermill hearing and go through those constitutional steps that are required.
The dates and the timing. So reading your brief, it sounds like in your opening brief, you argue that you should have gotten the report somewhere around, I think it's April 28th, when Doyle said no, and the report was requested, and Doyle said no. Reading your reply brief, you then seem to say, well, maybe it would be okay if we got it on May 12th or May 18th, after the captains had reviewed it and the chief had approved it, but still before the pre-disciplinary hearing. So what's the date you're arguing for?
April 18th is the date, because that's the date that the investigation was completed. In my reply brief, I used that example from the third largest city in Iowa that it actually happened. The idea is that when he completed the report, submitted it to the captains, that at that same time, he completes the results of the investigation. And as the evidence, okay?
That's where the city said, well, no, it's not done until, because at this point, the captains haven't reviewed it, the chief hasn't reviewed it. But even if you got it after the captains had reviewed it and the chief had reviewed it, it still would have been before the hearing, right? And that would have been an improvement over what happened, right?
The issue is we don't take issue with the review. It's the timing of the review in this case, and the idea that the district court and the city argued, and the district court found in their favor that the results of the investigation, the completion of the investigation, don't occur until May 31st, and that's when the punishment's imposed. And that's just not consistent with the text of the statute. The statute doesn't say that the investigation's complete when approved by the chief of police. It doesn't say it's complete when the officer is punished. That's not what it says. And so the district court mistakenly read language into the statute that simply isn't there and isn't consistent with it. And the other point about that that's problematic is that it creates constitutional issues. And we have to read the statutes and not to create a due process issue for these public employees, because under the Peace Officer Bill of Rights, they do have more due process rights. They also have more substantive rights than other public employees do.
So you're saying your argument is the city doesn't have to release it till they say it's complete. You don't agree with that argument to begin with. But what you're saying in your reply brief is, even if that's correct, that date was May 12th and not after and not May 3rd. Okay. I'm just trying to tease out the argument.
Because in the record, you'll see that in Lieutenant Doyle's deposition, there's language that's used interchangeably about the results of the investigation, the disposition. Is the disposition saying that the officer is exonerated, the complaint sustained? You know, there's different verbiage here that's being used, so that makes it a little bit more murky. But at the end of the day, the underlying issue here is that the district court failed to follow the text and the structure of the statute.
Aren't you combining two separate issues of when the investigation is complete and when the entitlement to the investigative report is triggered, right? And as I read 80F19, the trigger for actually having access to the investigative report is a disciplinary action, including removal, discharge, suspension. So if there isn't one, even when the investigation is complete, if the officer is not disciplined, where's the statutory right to get the file?
The officer's legal counsel upon request at the completion of the investigation.
Ignoring the entire first clause of the section that begins if. Like, there's an if-then statement in the statute, and you're just saying, well, the then gives me this right, but it seems like you're not wanting to acknowledge that there's a conditional before that.
It doesn't apply to the situation. I see that I'm out of time. Can I finish answering your question, Your Honor? With regard to this particular code section in that if statement, they're independent clauses. And so the officer still has the right to get to the investigation report and the witness statements through that final phrase. Otherwise, the legislature wouldn't have added that language in. Thank you.
My iPad's going to die, so excuse me for a moment. Sorry for that commercial break. Okay, you may proceed.
May it please the court, counsel. This court has appropriately seized on the biggest issue with the plaintiff's case here with regard to subsection 9 of the Peace Officer Bill of Rights. And that is that he's completely ignoring the first portion of it that says if an investigation results in discipline, then they're entitled to a copy of the investigative report and the witness statements. The city disagrees with plaintiff's position as to the purpose of that section. I don't think the purpose of that section is to allow the plaintiff to get all of the file before their pre-disciplinary hearing. I think the purpose is if there's discipline imposed, they get the whole file so that then they can challenge that discipline appropriately, whether it be at the Civil Service Commission or whether it be at district court later.
The hearing is part of the investigation, right? I mean, that has to be your position, right? Otherwise, it doesn't make sense the way you've put it together. That's your position, okay?
Part of it, because the chief of police, and this is made clear at the beginning of the pre-disciplinary hearing, and also I believe in the notice of the pre-disciplinary hearing, that the chief has not made any final decision until after that pre-disciplinary hearing, because the pre-disciplinary hearing is the officer's opportunity to bring in any facts that they want the chief to know or any arguments. So there's no final decision from the chief until after that hearing. So this is all part of the overall investigation, as is the review by the disciplinary board and any initial review by the chief.
Cover something different than subsection 9.
Subsection 3 would cover a situation where the investigation is complete, but there is no discipline. I don't think it's got that condition where there has to be discipline. So subsection 3 gives them a right once the investigation is complete, regardless of whether there is discipline or not, to get information about the results of the file.
Results of the investigation under 3, but in 9, they get the full file and the witness statements. The statements in, I lost my place. So some of the letters talk about reviewing the investigation in the past tense. So like the May 2nd letter from the disciplinary board to Chief Yonkers says the members met to discuss the findings of the investigation. And similarly, the May 18th letter from Lieutenant Doyle to Smith and notifying him about the May 25th hearing talks about the investigation in the past tense. The administrative investigation was undertaken. So convince me that the discipline is part of the administrative investigation as opposed to there being two separate periods there.
I think there are two types of an investigation going on here. There's the internal affairs investigation that is done by, it was then Lieutenant Doyle, he's now a captain. His investigation, I think, is what's being referred to in some of those notices that you're looking at, Your Honor. The overall formal administrative investigation is larger than that. It includes what the disciplinary board's looking at, their recommendations, any follow-up they have, any follow-up the chief has, and any results or additional information that's provided at that pre-disciplinary hearing, in our view.
Will apply or require to be provided to the officer in advance of the pre-disciplinary hearing?
Just requires they be provided with notice and an opportunity to be heard. And I believe the Loudermill case even goes so far as to say, that the procedure that's required is not an overly formal one. This Loudermill hearing is not meant to be the end-all, be-all, the last thing that they get to say in the matter. It's an initial kind of screening. So I think it requires that they know essentially what they're being charged with and what the possible ramifications are, but not that they have the whole file.
Been construed to require they get witness statements?
Your Honor, and I believe in cases where discipline is not imposed, in other words, that condition in subsection 9 doesn't kick in, it makes sense from the city's perspective that they wouldn't necessarily get witness statements. There's no discipline that's been imposed. There's no reason they have to file any sort of a challenge. They haven't been damaged. And it would not be uncommon for some complaint investigations to include confidential or sensitive complaint information about people who want to remain anonymous, particularly when you get citizen complaints. In this case, it wasn't a citizen complaint, but we do get those, and those are covered by ADF as well. So it's balancing that interest between providing these anonymous complaints or these citizen complaints when it's absolutely necessary to defend yourself against discipline, and keeping them private when it's not.
You meant that subsection 13 permits claims against people that filed claims that didn't actually result in discipline.
The subsection 13 does permit that, but I think in order to proceed on any sort of a cause of action like that, you would have to have some sort of damages. And I don't think there's any damages to be had if you haven't been disciplined and there's been no negative consequences of the complaint. So I think it goes back again to, I think we're balancing when they really need the information versus when they're not. Did that answer your question?
So, I mean, I could think of a situation, though, even where you might prevail, that there's still been harm because you've had to go through the whole process of getting counsel and having to deal with it if there's a false claim.
And I think if litigation were filed, ADF does not necessarily prevent a party from, getting a subpoena or trying to do discovery in that litigation to get those witness statements. ADF just covers when the city is required to release them upon request. Them being subpoenaed or requesting a discovery in litigation is a completely different beast. And there may be protective orders that are needed at that point, but I could see a court ordering information being released subject to a protective order.
Well, swimming in a lake that I'm not familiar with here. What I heard you say a little while ago is that the investigation is not complete till after the pre-disciplinary hearing. But what I read you saying in the brief is it's not complete until it's approved by the chief of police, and that's your written policy. But wasn't it approved by the chief on May 12th?
We don't believe it was, Your Honor, and that's actually one of the things I made a note that I wanted to address. There's two parts of the reply I wanted to address. This argument that it was approved by the chief on May 12th, that was raised for the first time in the reply. Prior to that, throughout the litigation, you'll see that the chief's approval date was always May 31st, and everyone agreed on that. Then the reply gets filed, and all of a sudden it's May 12th. And I think under the rules of appellate procedure, you are not allowed to assert for the first time in a reply brief issues. So Unfortunately, because it wasn't raised until the reply brief, the record below is not developed at all on what those sketchy notes next to the chief's name even mean. You know, had it been raised, we would have submitted affidavits explaining what that means, but those aren't there, unfortunately, because it was raised at such a late part of the proceedings.
Everyone agreed that if it's not, if the relevant date is the chief's approval, that didn't occur till May 31. Is that what you're saying?
For saying that that's the legal position, or what's your authority to say the chief gets to decide when it's complete?
I think the thing we need to look at first and foremost before looking at what the chief says and what our policies say is the definitions under just common, ordinary English language when an investigation is complete. It's when all details have been collected and everything's been wrapped up in a bow. That's when the chief approves it. And I think also because the statute doesn't lay out exactly what it means for an investigation to complete or be complete or at what point in time, I think the legislature has left it to the municipality or the governing body to adopt a policy like we have if they deem necessary.
Defines formal administrative investigation, at least. And that's the overarching investigation you're talking about compared to the internal affairs investigation, right? Okay, and that says it's an investigative process, but you were to determine the merit of a complaint, which may be the basis for seeking removal discharge. Does that suggest that you have an administrative process first? That's completed, and then you determine whether or not to go ahead and seek removal, discharge, or suspension?
I don't believe so, because I think as we argued in our brief, the reference to something may be a basis for seeking removal, that's just referring to the complaint. So the investigative process is ordered and the questioning of an officer is intended to gather evidence anytime there's a complaint that might result in discipline. So I guess I don't read it that way, Your Honor.
Language to just limit what is a formal administrative investigation. It's the only when there's a complaint that could lead to. That's how you're reading that. Correct.
The other thing I wanted to touch on briefly, if there aren't other questions, is in subsection D of the plaintiff's reply, there is this argument that the city's argument that the police chief could order additional information or request additional information. It's argued that that shouldn't be considered because that's speculation and conjecture. We would disagree with that. I think the affidavit that's in the record establishes that it is a fact that this has happened in the past. And it is a fact that this was allowed in past practice. And it is a fact that this was an option in this case. And we couldn't have known if that was going to happen until, we got all the way through the process. So we disagree with the reply's arguments there. We also disagree with the reply's argument that Lieutenant Doyle's affidavit is self-serving. The cases cited in support of that argument, basically one of them involves a party who's making the affidavit. And it's important to remember Lieutenant Doyle isn't a party here. There's no evidence that disposition of this case impacts him in any way. So I don't think it's appropriate to say it's a self-serving affidavit.
Raise a practical concern with your views. So let's say I'm an officer and there is one of these sort of malicious citizen complaints against me, and that those things do happen, and it ends up going to a hearing, and in the end, I'm exonerated. The charges are dismissed, but I want to pursue an action against this citizen who made a malicious and false complaint. How do I get access to the information to do that?
In my view, you would file a lawsuit. You may not be able to name the individual at the start of the lawsuit. You can name them a John Doe or a Jane Doe. File the lawsuit, and at that point, you have a right to discovery and you have a right to issue subpoenas. And I think if you're naming the party as the city as a party, I think you would serve discovery, and the parties could work on a protective order, and you'd get it that way. And then you amend your pleading to name them.
Counsel, this is the second ADF case that we've heard this term. Earlier, we heard a case by a peace officer with the Department of Corrections who argued that Chapter 13 claims did not apply against the department at all. Is there any argument like that in play in this case, that the city is not among those that could be sued under subsection 13?
We certainly have not made that argument, Your Honor. Let me just look at the language of subsection 13.
And I'm referring to a cause of action against any person, group of persons, organization, or corporation for damages.
You know, I certainly think that the subsection 13 could be read narrowly to not include a municipal corporation. But I won't represent to this court that we've made that argument in this case.
Is there an administrative proceeding that could have taken place instead of this?
As Mr. Limkemann noted, there was a civil service appeal that was filed that was stayed pending this action and presumably maybe reinstituted to challenge the suspension itself. I've not ever had this come up, and so I don't know if the Civil Service Commission would have jurisdiction to rule on a legal issue like this, which is part of the reason we decided we need this decided. We need to know what the answer is. Let's let this go forward.
What was the underlying dispute about? Why did he not want to provide his picture to be posted in a private hallway, and why did the city need his photo there?
Posts official photographs of all the officers in this hallway where there's not ready public access. And my understanding of is he had some concerns about the city using his photo in ways he didn't want it used. He wanted to control his image, I think he said. And he had some concerns. He's one of the few African-American officers. And I think he felt, right or wrong, like there'd been some misuse of him. But that's not an issue in this case anymore.
And I'm going to ask your colleague this, so it's fair, but can you explain to me the difference in the relief that's being sought in the administrative action versus what's the relief that's being sought here?
Admittedly, I've not looked at the civil service appeal in quite a while, but I believe the civil service appeal, the officer was ultimately suspended for, I believe, 10 hours without pay. I think they would be asking the Civil Service Commission to reverse that 10-hour suspension, so presumably get his money back for that 10 hours, is my guess, but opposing counsel could probably answer that a little better. Versus in this action, they're looking for a legal declaration and presumably attorney fees. And with that, I see my time's up if nobody has any other questions. Thank you.
Answering that question for me as well, see if I'm on the same page as far as the relief being sought in the two cases. Yes, sir.
So the civil service appeal is directed at the disciplinary action. With regard to the ADF 1 action, we're seeking injunctive relief, the attorney's fees. Obviously, we're trying to get the statute interpreted and not believe that the Civil Service Commission, one, has jurisdiction over this legal issue or is the appropriate group to ultimately decide these legal issues and try to get those things addressed. Part of the injunctive relief, frankly, we just want them to change the process so that when these things happen, that they provide those written reports and the investigative witness statements as part of these investigations to the officers prior to the pre-discipline hearing, so that way the officer has a meaningful opportunity to respond. And then that way, when they're providing the results of the investigation, the officer's getting those at the time that the investigation's completed, not at the very end when they're punished.
That's really relief for folks going forward.
In this particular case, yes, that would be correct. We're trying to get these things hammered out, and really the big relief that the district court would be awarding here, besides the injunction, would be the attorney's fees. Also, the district court, though, could do the actual damages, which would include the suspension. So they could award the back pay through that as well, which would probably result in us withdrawing the civil service appeal. With regard to a couple of the other questions, I just want to note a couple of things for the record. First, as far as the Peace Officer Bill of Rights is concerned, the bill is there for the benefit of the peace officers. This provided additional rights to the officers. The Fraternal Order of Police was the one that brought the legislative proposals together for this, going all the way back to 2018, 2019. And when you look at the legislative history, there is a lot of history of different language back and forth that's been used for this statute. Some of the language is not perfect in ADF 1 subsection 9, just like it's not perfect in a couple of the other provisions. We have to remember that the legislative session in 2021 was during COVID. There was a lot of people that were unable to work, in person, things like that, and the legislative process was not the normal one. So while that, it's not a perfect code section, I think that we have to look at ADF 1 subsection 9 and read the new language they added in there and look at that because they said the complete investigative agency's report and then upon the completion of the investigation. And they wouldn't have added that language if they didn't intend to give the officer through legal counsel the right to do that. And really, the statutory scheme is such that if we don't have the right to get the written report and the witness statements, it's going to defeat a number of the other provisions of this code section, including ADF 1 subsection 13. When we look at some of the other intent of this code, it was also to provide officers not only just more due process, but to improve the process overall. If you look at ADF 1 subsection 21, they required training for the people that are conducting these investigations.
Me that, in that hypothetical that I gave Ms. Kropf, that it'd be kind of unwieldy to have to sue a John Doe. And also, it's hard to know whether there's malice or whatever you would need to defeat the qualified privilege that you get for, I guess, reporting people to the government without knowing who the person is and what the circumstances were.
That's absolutely right. What we're ultimately asking the court to do is just draw a clear distinction here. It's a very easy rule to apply. It's very workable. We have to think about the results of this opinion in terms of all officers under the code, not just law enforcement employed at a civil service city. And so if the holding in this case, what we're asking for is that the court should interpret the statute to conclude the investigation is completed within the meaning of the law when the investigator ceases investigation activities. That 9 times out of 10 is going to be when that report is drafted, and at the same time then they say here's your results of the investigation because the code ADF 1 subsection 3 says immediately. And so with that interpretation, there could be exceptional circumstances that come into play, such as military leave, a criminal investigation, somebody dies, there's things like that happen, but that's a very easy rule to put into place for everybody to apply. The other thing that we're asking for is to just draw a very clear line between the investigation process and the discipline process. Obviously, the investigation has to be complete before you go into the pre-discipline process. We don't punish people prior to doing an investigation. And then finally,
So I'm clear on that. I think your opposing counsel was making the point that there might be something new learned through that pre-disciplinary hearing, or the police chief on the eve of sort of making the decision might say, why don't we look at some more things? Why don't we continue with the investigation, look at other things? So it seems to me not unreasonable to say that maybe the investigation wouldn't end until the final disciplinary decision is made. I mean, we don't want folks to be disciplined before all the avenues have been explored, right?
I see I'm out of time. So with regard to that, you're correct. We don't want to discipline somebody without having all the facts. But the pre-discipline process, as it was used in this case, and as the district court ruled, would not allow us to do that because we don't know what we're responding to. And as you look at the transcript that we had made of the pre-discipline hearing in this case, Officer Smith is telling them, I don't know what I'm responding to because I don't know what the facts that were found. I don't know what the witnesses said. I don't have this information to provide a meaningful response to what you're saying. And so the idea of this with ADF 1 subsection 9 is to get that information out there so the officer has the meaningful opportunity to respond and so that they can get to the right result. That's the only way that the statutory scheme is going to work. I see that I'm out of time. Thank you very much.
All right. We will take a brief pause before our next case, which is Burton versus West Bend.